Okay, we will now proceed with our final case on the docket today, Eady versus the Agency for Healthcare Administration. Counsel for appellant, you may proceed when you're ready.
Thank you, Your Honor. May it please the court, Floyd Fagley for the appellant, Brandon Eady. I'd like to reserve 5 minutes for rebuttal. Again, today's case, this is a final order that was entered prior to the Florida Supreme Court's decision in Geraldo versus Agency for Healthcare Administration. Just like the previous one that was argued, the administrative law judge below did not have the benefit of that decision. In this case, in the Brandon Eady case, the facts are very similar, if not identical, to the Geraldo decision. As identical to the Geraldo case, in Brandon Eady's case, he presented the unrebutted expert testimony of 2 experts concerning the value of his damages. His position was his damages were far in excess of $15 million, and using $15 million as the value of all of his damages, his $1 million settlement represented a recovery of 6.6% of the value of the damages, and accordingly he recovered only 6.6% of his $177,000 claim for past medical expenses. And he proposed an allocation of $11,000 and some change to past medical expenses. The experts, both experts testified to the value of the damages, and that this that $11,000 is the portion of the settlement which should be allocated to past medical expenses. Redundant testimony from the experts. This is identical to Geraldo. And identical to Geraldo, the Agency for Healthcare Administration did not present any evidence concerning the value of the damages, did not call any witness to testify concerning the value of the damages or an appropriate allocation of past medical expenses, and the Brandon Eady's testimony was unrebutted. His evidence was wholly unrebutted. The administrative law judge below, in entering her final order, rejected the unrebutted testimony because she stated, or as she stated in her final order, Brandon Eady's position was thwarted. That's the word she used, due to the confidential nature of the settlement and the settlement agreements not being provided to the administrative law judge. And because these settlement agreements did not provide that 6.66% was allocated to past medical expenses, the agency was entitled to full payment of its lien. This was
Mr. Fagley, you would agree in a lot of cases it would be difficult to utilize the settlement agreement as evidence to establish what is reasonably allocable. Would you agree with that statement?
It would be difficult to use the settlement agreement?
It's difficult in the sense that you may have privilege issues, not only confidentiality, but mediation privilege, attorney-client privilege, work product privilege, risk management privilege if you're dealing with a med-mal case. Yes. So the fact that the ALJ seems to say in her final order that that was necessary would be an impediment in a great percentage of cases, would it not, as far as being able to utilize a confidential settlement agreement?
Yes, it absolutely would, and that's the reason we didn't file it in this case. We had a number of settlement agreements with the various defendants. They were confidential, and there was nothing in there that was relevant, and most importantly, it was a stipulated fact that the a series of settlements totaling $1 million. There was nothing else necessary to file the confidential agreements. But yes, it would be difficult to put those on the record. And as I've outlined in my brief, I don't know if it's relevant because the purpose of these administrative hearings is to determine the portion of the settlement which should be allocated to past medical
And
expenses.
that was my next question. Is it ever germane? Because we have a state statute that says it can't be used against ACA if ACA was not a part of it, correct?
That's right. That's right.
So can you envision a circumstance where it would be germane?
No. Now, if there was an allocation to past medical expenses in the release documents, it could be filed with the court as support for an allocation of past medical expenses. It's not binding on ACA if ACA is not a party to the settlement, but it could be used as a piece of evidence. And I don't know how much weight it would have if ACA was not a party to the settlement, but maybe in that circumstance. But in this case, that was not the circumstance. It's an unallocated settlement. Lump sum, we got $1 million. That's a stipulated fact. So no, I don't think it's germane. And that's the core error with the administrative law judge's final order, as she said, Brandon Eady's position was thwarted because he didn't provide that confidential information. And those settlement agreements, he didn't prove that those settlement agreements allocated 6.6%. I couldn't prove that because there are lump sum settlements and there was no allocation.
So how is this case different from the case you just argued where in that case, the ALJ was looking for the amount actually allocated? And here, it seems like the judges, they're striving to find a more concise way to establish what is allocable. So how is this different in any meaningful way in terms of what happened in the end?
In the previous case, the judge was applying the wrong standard. She was desiring to, or requiring that the appellant prove the actual amount recovered. And I don't know how that's provable without a jury verdict or a bench verdict saying this is the amount. And that's binding on everybody.
Right, and here the ALJ wants that settlement agreement, that confidential settlement agreement, I think, to provide some indicia of what the amount allocable to past medical expenses is.
If it had been provided to her, it wouldn't have stated the amount allocable to past medical expenses because it was a lump sum settlement. The purpose of these 17B proceedings is to determine the agency's, or the amount allocable to past medical expenses when the agency doesn't participate in the settlement. That's what the First District Court of Appeals, Judge Jay, I believe you wrote the opinion, and Delgado stated, is that when the agency doesn't participate or approve a settlement, the 17B proceeding is meant to prove the portion of the settlement allocable to past medical expenses in lieu of the 11F formula. So the purpose of this proceeding is to put on expert testimony concerning the value of the damages, the amount that which should be allocated past medical expenses, or as the Florida Supreme Court said, fairly allocable to past medical expenses, and have the administrative law judge make that determination. And
Mr. Fagley, I want to clarify one point, and Judge Ray touched on it, but was it undisputed in this record, in front of this ALJ, that those confidential settlement agreements made no differentiation among the types of damages? Was that undisputed by virtue of stipulation, or we just don't know that?
I believe the stipulation in the joint pre-hearing stipulation, which would have been on page 10 or 11 of that stipulation, said that the case settled for a series of confidential settlements in the total amounts of $1 million. But the agency had the settlement agreements. If there was something there that was helpful, they could have filed the settlement agreements as an exhibit. I guess the answer to your question is
Do we know?
do we know?
Yes, sir.
Well, I know.
Well, and it's certainly, I don't want you to violate, by no means, nor do my colleagues want you to violate any privilege, but is it in the public record whether there was a differentiation in those confidential settlement agreements?
There was no differentiation in the settlement agreements. It was a lump sum unallocated million.
I think you've answered my question.
And if I could ask a quick follow-up question, even if there was a differentiated settlement agreement, since ACA is not a party to that, is it relevant to the ALJ's job here to determine what is allocable?
As I stated in my initial brief, I think it's irrelevant. It may be considered a piece of evidence, but it's not binding on ACA. It's not, I wouldn't think it would be substantial enough to meet the petitioner's burden of proof by preponderance of the evidence, what should be allocated. I know the agency, if I was sitting in their shoes, I would be standing up on a soapbox screaming it's irrelevant, what Mr. Fagley has in those settlement agreements. No, it's not relevant. And that's the core error here, is that the administrative law judge said the unrebutted expert testimony of Brandon Eady's experts, she rejected that because she believed the settlement agreements had to have an allocation to past medical expenses contained within them to successfully challenge the Medicaid lien, and that's error. And that's not a reasonable basis in the evidence for the rejection of unrebutted expert testimony from Mr. Eady's two experts. Am I out of time?
You're at 4 minutes and 15 seconds left.
Okay, I'm gonna pause there. Thank you.
May it please the court, Alexander R. Bowler on behalf of the Agency for Healthcare Administration. As I'm sure this panel is aware from the previous argument, there is federal and Florida law that both require and charge the agency with recovery of what it has expended on behalf of Medicaid recipients when that Medicaid recipient has recovered from a liable third party. Here the agency expended about $177,000, and Mr. Eady recovered $1 million in a gross settlement from a liable third party. Under Florida and federal law as well, a Medicaid recipient has the opportunity to prove what was recovered for the past medical expense portion of his recovery.
Mr. Bowler, is it ACA's position that in order for an ALJ to make this reasonable allocation, that you need the settlement agreement? Is that the position of ACA?
No, you do not need the settlement agreement. As Mr. Fagley explained, it might be helpful, but the agency would take the position that it's not binding on the agency, and it is usually just the product of the attorneys for the Medicaid recipients, not the product of the settling third party.
Well, then would you agree that the ALJ here committed error by saying that without the settlement agreement, there was a failure of proof?
If that alone was the basis for her finding that the Medicaid recipient failed to prove what was recovered for past medical expenses, perhaps indeed she did commit error. But I think you've got to look to whether or not the Medicaid recipient proved what was recovered for past medical expenses. He did not, because while he may have proven that $15 million was the so-called value of his case, and while the parties stipulated to $1 million as the gross settlement, and $177,000 and some change as the Medicaid lien, and the entire claim for past medical expenses, the agency did not stipulate to, and Mr. Eady did not prove that you can just use those numbers and somehow wind up at what was recovered for past medical expenses.
What about the testimony, and I think it's page 69 of the transcript, where Mr. Garrett is asked, is this percentage, the 6.6%, a reasonable allocation? given the settlement in this case, based on your experience and training, and he says yes, what do you do with that unrebutted in this record?
Mr. Barrett was
Is it
proffered.
Barrett? Is it Barrett?
Yes.
Oh, I said Garrett. I'm sorry.
Mr. Barrett was proffered as a expert in the allocation of damages suffered by injured third party, an expert in the valuation of damages suffered by injured persons. He was also proffered as an expert in an allocation of a settlement. The agency objected to that proffer, and the ALJ decided not to accept him as an expert in the allocation of a settlement. There was no basis in his testimony to show that he had expertise in that area.
Well, what about the fact that he's been accepted 15 times as an expert in allocation, according to him?
He's been accepted 15 times in the determination of the value of damages. So that $15 million figure that he is putting on the case, and Mr. Guito also put on similar testimony as to $15 million was the value of Mr. Eady's case. Mr. Barrett was accepted many times as an expert in valuation of damages, but not in the allocation of a settlement.
Why, though, help us understand why Mr. Barrett would not be an expert in allocation when you have a longtime trial lawyer who testified about his intimate knowledge with these types of cases, these types of damages, verdicts in these types of cases, liability issues in these types of cases, settlements in these types of cases. Why would he not be an expert in allocation?
Well, in the record, he does not explain his background for purposes of determining allocation of a settlement. He does talk about a little bit about you might need to know allocation for tax purposes, or you might need to know allocation depending upon how attorney fees work out, because some damages have different attorney fees than other damages.
But is not allocation simply the components of a verdict or the components of a settlement, meaning how much you're being paid for past economics, future economics, past lost wages, future lost wages, past non-economics, future non-economics? Isn't that the same thing as allocation, the components of a settlement or the components of a verdict?
Yes, and here we do not have a jury verdict, and here we've got a lump sum settlement.
And so when you have these situations, which actually happen more frequently than is fortunate, is how do you go about what expert testimony would be required to meet the burden that ACCA is requiring here?
I believe testimony as to what was actually recovered for past medical expenses.
But there was $1 million undifferentiated, so how could he possibly, I mean, you're basically setting up an unrebuttable presumption, is what it seems like to me, that there's no way they can rebut this if there's not a trial. So the state of Florida wants to make everybody go to trial on these things and have a jury sort all of these out. That doesn't seem like a real efficient, in the grand scheme of things, way to handle all of these cases, given that, 95% of civil cases resolve before trial.
Right, Your Honor. I don't think these cases need a trial, but what they do need is the petitioner at the 17B proceeding to put on what their recovery would be for all of their damages.
And again, how do they do that? I'm sorry, I'm really struggling with this. How do they go about meeting that burden when you have an undifferentiated lump sum settlement, no jury verdict, itemizing the damages?
It might be an expert who, like Mr. Barrett or like another plaintiff's attorney or defense attorney who could testify to that. Here, there was no basis for Mr. Barrett's testimony as to that issue, and the ALJ did not accept him as an expert in that field. even though he was proffered.
I'm having some difficulty with that, why you're saying there's no basis. When he goes through and talks about the catastrophic nature of these damages, page after page after page, the types of damages in these cases, the types of these damages in other cases he's familiar with, and then he applies that to the settlement. I just don't know how it can get any better than that. But help us understand how that's not a good enough thing.
Well, his testimony for pages and pages is in regards to what Mr. Eady's damages were.
Correct.
And so that's how he got to that $15 million as a conservative value of Mr. Eady's damages. But there's no requirement in the law, and the Fifth District Court of Appeal, for example, in Smith versus Agency for Healthcare Administration, explained that there is no requirement in the law to use this sort of pro rata allocation.
Isn't Smith kind of suspect post-Geraldo?
I don't think so, Your Honor. Although in Smith, they do talk about just all medical expense damages rather than past medical expense damages. The court there, and it was then Judge Lawson who wrote that opinion, talked about the pro rata approach being problematic, and it might work in some cases, but it also might not work in some cases.
Well, what other approach is, I mean, obviously, we're not supposed to do a one-size-fits-all solution per the U.S. Supreme Court, but besides a pro rata approach, how else do you get to a number if there's an undifferentiated settlement from, and there's not been a trial where a jury says, well, the economic damages are X. How else do you get to that except for a pro rata approach?
Your Honor, I'm not sure. You might use a weighted approach based on what caused the liable third party to settle. The Medicaid lien is also a very precise number, whereas other types of damages, non-economic damages specifically, Mr. Barrett and Mr. Guito, I believe they refer to them as sort of vague. And in those cases, for those damages, they refer to them as ranges, whereas the Medicaid lien is a very specific number. So one might use a sort of weighted approach based on why the liable third party settled.
But the only way to know that is to ask the third party, the non-party to this proceeding, and that would be privileged. Would it not? I mean, it would be confidential. It may be a mediation privilege. It would very much be attorney-client and work product. So why would that not be a privileged bit of testimony to say, well, why did you settle this case? I mean, could they ever be a witness unless they volunteered to waive all those privileges? I just don't know how you would go about establishing why they paid what they paid. Sort of Judge Bilbrey's point that we would be creating an unrebuttable presumption by requiring that kind of evidence. But maybe I'm missing something.
Your Honor, it very well may be privileged, but there might be other indicia of why it settled. But that's just a hypothetical way to do it. The pro rata approach may be the right way to do it in some cases. But the burden is on the Medicaid recipient to prove that it is the correct approach.
What is the correct approach?
That the approach used here, that the pro rata proportional approach is correct. Here the Medicaid recipient did not do that.
So you would concede that can be, in the right case, the correct approach. You're just saying the evidence here, or the testimony here, didn't rise to the level it needed to.
Correct, Your Honor.
And is that because the experts weren't properly qualified, or was there also a failing in the evidence?
Both, Your Honor. I believe they weren't properly qualified because there was no foundation laid for them to testify convincingly to that issue. And because there was no foundation, there was no reason for the judge to accept their vague statements about the reasonableness of the approach.
I'll ask a question I asked in the past case. If we disagree with you and think that the ALJ had some error here, should we send the case back for the ALJ to conduct further proceedings? Or do we just say, okay, 6% of X equals Y, and we send it back with the direction that the ALJ assess the lien at, whatever the number works out to be?
It might depend upon why this panel decides to send it back to the ALJ. If it's just to do math, I'm sure the panel can do it as well as the ALJ. And if the panel believes that there is sufficient evidence in the record to determine that the pro rata approach is correct in this case, then the panel can do that without sending it back to the ALJ to determine that. But if there's other questions outstanding or for further evidence for the petitioner to put on regarding that pro rata approach, I think the record does not need to be reopened. If there's nothing further, the agency respectfully requests that this panel affirm, and I'll yield the balance of my time. Thank you.
Thank you.
Let's have a few quick points. I want to thank the agency in this case for showing candor in their briefing concerning the last paragraph of their answer brief, right before it says conclusion. They acknowledge that the filing of the settlement agreement is not necessary in order to successfully challenge the payment of the Medicaid lien. And here, in oral argument, they also say that, that if that's the basis of the ruling, then that's error on the part of the administrative law judge. And that's what the administrative law judge did here. She said Brandon Eady's position was thwarted because of the failure to provide those settlement agreements as confidential settlement agreements, and those settlement agreements didn't prove up that 6.6% should be allocated past medical expenses. That's the basis of her rejecting the unrebutted testimony of Brandon Eady's two experts, and that's not a reasonable basis. That's actually an erroneous basis, and it's not a reasonable basis in the evidence for the rejection of the unrebutted testimony. One question posed is, why isn't a trial lawyer qualified to testify concerning the allocation of settlements? And the simple answer is they are. I don't quite know what an allocation expert would be, other than a trial lawyer with 40 years experience or 41 years of experience like Mr. Barrett, who now has testified not in 15 cases here at the Division of Administrative Hearings, but he's pushing 30 or so cases where his testimony has been found competent and substantial and convincing by the administrative law judge. And I want to point to footnote 1 of the answer brief. It's math. This allocation is just simple math. You know the value of the damages, the conservative value of the damages. You can run the numbers pretty easy. I don't know if we need an expert to do math. As the agency says in footnote 1 of its answer brief, basic arithmetic bears this out. It's math. So I don't know if we need someone to testify concerning how a mathematical equation works, but in this case, Mr. Barrett and Mr. Guito both testified that a reasonable allocation to past medical expenses would be $11,838. The U.S. Supreme Court addressed who should testify in its decision in Woes versus EMA. On page 1400 of that decision, they state that trial lawyers can find objective benchmarks to make projections concerning the value of the damages. So even the U.S. Supreme Court has pointed to trial lawyers as the appropriate party to provide this testimony. So I also want to point out that in this case, Mr. Barrett and Mr. Guido testified 4 days after the final hearing in another matter and were found credible by Administrator Lindsey Bogan. He agreed with them, but this judge did not because of the lack of the settlement agreements. So with all that being said, we have unrebutted testimony here, unrebutted evidence. The agency didn't provide anything. And it was rejected because the settlement agreements weren't provided. And that's, according to the administrative law judge, that thwarts Brandon Eady's position. That was error. It was not a reasonable basis in the evidence for the rejection of the unrebutted testimony. And we're asking for a reversal. There's nothing further that needs to be done on this case. We're asking that instructions be given that the agency accept $11,838.01 and on remand in satisfaction of their lien. Thank you. Unless there's further questions.
Thank you to both counsel.
Thank you
We
both.
stand adjourned.
All rise.